Unfortunately, in BTC2, the president was President Rodrigo Duterte. And as mentioned by my friend Benny Bacani, at the start of his administration, he said, internally, I will implement all signed agreements, not only with the Bangsamoro, but with the NDF at that time. So he has a roadmap. President Rodrigo Duterte has a roadmap. The roadmap for peace and development. And among that is the implementation of the comprehensive agreement with the Bangsamoro and the implementation of the 1996 final peace agreement. But this has to be subjected to legislation. And I am fortunate to have been appointed in the office of the presidential advisor of the peace process. In knowing how administration after administration shaped its peace policy, various projection that we are presently in an uncertainty is correct, because the president is always the head of the peace process. Head of the peace process, the OPAP's implementation is directed by what the president wants to be implemented. Now, the election is over, and we have a new president. We really don't know who will become OPAP secretary, and we have not seen, as Ben said, what is in the mind of the resident Ferdinand Marcos. But we have a glimpse of what can be the perspective of President Ferdinand Marcos, because in DTC1, he was the chair of the Committee on Local Government. And these proposals were all based within the context of the 1987 Constitution. And he has a model of two autonomy in that proposal. So these are some inkling into what his committee has and what he may have in mind in the past. But I hope that will change with the unity team as the administration of the next Philippines. Now, we wrote this to serve as a guide not only to student of law, but to the Bangsamoro, but also to the next administration. To see to it that the next administration is guided by the legislation which was passed in the past. Although we know that any administration can reshape the legislation already passed. Laws can be amended. There is no such thing as permanent laws. And the implementation of such laws can also be executed by the President through executive orders differently from the past administration. And this Bangsamoro Organic Law or BARM book, with perspective, will have to give the next administration the hindsight of the difficulty of shaping up an agreement, at the same time of legislating such an agreement. So that the next administration will realize that we have started, and the completion of which now is in the hands of this administration to fully implement what has been shaped in the agreement and what has been legislated in this law. So this is the most important perspective of this whole round. We know that we have already the BARM, and in the old BARM there are some limitations and there are some restrictions. For example, our black branch under the present 1105 is subject to review every 5 years from the implementation of the law. Unfortunately for us, the review will be 2022. And the second is all national projects implemented by national agency for the BARM will stop unless re-implemented in the national government by 2023. These are some implications. There are some implications to the region because of all this. And thirdly, many of the provisions, like extension law. The extension law did not provide a clear guide as to how the president should tackle the Bangsamoro transition authority. What is just provided under Section 2 is the president may appoint. So the question is, will the president appoint or not? That is an issue that has to be brought upon by the next administration. Secondly, with respect to the provision on the leadership of the PTA. There is much question there because, for one, this is now an extension of the regular implementation of the Bangsamoro Transition Authority, thanks to the help of President Duterte for granting us an extension. But that is still subject to the prerogative of the next president. So these are the things that we have to look into. I hope this book will give the president a very good perspective on how he will navigate the Bangsamoro Autonomous Region in Muslim. Thirdly, we are still with the intergovernmental IGR works. There are many works which have not been completed, among which is the delineation of the territorial boundary of the bar. Whether it will go through or whether there are new modalities to implement the bar is again a question that has to be looked into. We tried very best, together with the co-authors, to give the new administration a perspective of how the comprehensive agreement was negotiated, how we resolved the contentious provisions in the agreement, and how Congress shaped that provision and legislated into the current Republic Act 1105. So this book is timely because this will serve as a guide not only to the President, but to his appointed members of the Cabinet, particularly the OPA. Secondly, this is also telling, because even now, if you go to the national government agencies, they say you have no bar. It has nothing to do with you. They deny provision in the board that the national government can still carry with it programs for the bar. So all this must be shaped very carefully in the provision, in the discussion, in the book, in order that we will be able to elucidate this provision and that this will serve as guide to the new members of the Cabinet of the next administration. Secondly, this should also be good tool for the present DTA to implement. There are provisions in the all bar which have not been fully implemented, I must admit, by the current administration of the bar. For one, the BTA should have been a member of the IGR because it is stated in the provision of the all bar that the IG, or purposes of intergovernmental relations, it is the BTA that is the government of the day. But in the IGR, I recall, except for the membership in the Bangsamoro Congress Parliament Forum, we don't have members. Very few of them are for the BTA. So these are issues which has to be tackled with the current leadership of the bank if we have to move forward. And I hope, together with the co-authors, we have given our fair share of enlightenment and directing not only the next administration, but the administration of the bank, so that we can equally carry the burden of the work within the context of the rule of law, within the context of all bar, and that we can move forward together to bring unity. Very mentioned about intergovernmental relations. Where there is a shape of intergovernmental relations with the national government, we have paid considerably to craft up a legislation and local government code within the context of the whole bar. The local government code is the mechanism of intergovernmental relations between the bar and the local government units. But as of the moment, we are just relying on MME Act 25 and law passed by the R. We have not only implemented, even drafted. We have drafted the local government code, but we have not even done our fair share of consultations with the local government to bring the region together to one vision, one direction, and one objective. I hope in the next coming days, we will be allowed to pursue with the consultation of local government and finally pass the local government code so that there will be a permanent structure with respect to the relationship of the region and the local government. Failing to do that, the Bangsamoro Transition Authority will be a total failure because we fail to unite the region. Lastly, let me end my message by just quoting a statement. He said, this is an anonymous quote. he who is enslaved by the past will not try in the beginning. It doesn't mean that we forget the past, but let the past be a tool and a guide to help us. But we should not be enslaved by the past, because the future is shaped by the present, and the future should be relevant and meaningful to the Bangsamoro. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Attorney Joe, for that inspiring message, and of course for highlighting the prospects, the challenges, and the need for continuing conversations on the legal and constitutional reforms. At this point, we shall be joined by one of the authors through Zoom. The author is a career foreign service officer and a lawyer by profession. She headed the legal team for the Philippine government in peace negotiations with the Moro Islamic Liberation Front in August 2010 until she was appointed by the President Benigno S. Aquino III as member and commissioner of the Bangsamoro Transition Commission in April 2013. She received her Bachelor of Arts degree in Philosophy, Magna Cum Laude, and Juris Doctor degree from the University of the Philippines, and gained her Master's in Law from Georgetown University as a Fulbright Scholar. Ladies and gentlemen, live from Kuala Lumpur, Malaysia, please help me welcome Attorney Johaira Siwa. Attorney Jo?
Hello.
Take it away.
Good
Yes.
morning and greetings from Kuala Lumpur. Narinig niyo po ako? Okay. Well, thank you very much for the very kind introduction. It is an honor for me to be with you today, at least via Zoom, for the launch of this book on the Bangsamoro Organic Law Framework and Annotations. I extend especially my greetings to Attorney Dr. Mike Mastura, who was a former member of the panel of the Moro Islamic Liberation Front and a very valuable advisor to their panel, members of the Bangsamoro Transition Authority, members of the academe, and colleagues from the civil society organizations in Mindanao. I am currently in Kuala Lumpur serving in an embassy here, and I wish to thank the Institute of Autonomy and Governance, not only for having me be part of this book, but also for accommodating my presence today via Zoom. And I also thank the Australian government for its support for the publication of this book. So I was invited to write a framework chapter for the book, and my inspiration really was were my experiences as head of the legal team, first for the Philippine government, and eventually as member of the Bangsamoro Transition Commission. 2008 was a turning point for the peace negotiations. After what happened with the MOID, we learned many lessons, and among them was the realization that while the peace negotiations were not really, strictly speaking, a legal exercise, there was still a need for issues and positions to be considered also from the viewpoint of the Constitution. Because after all, under the Philippine system, the Constitution is still the source of all government authority. When I headed the legal team for the Philippine government in the peace negotiations in 2010, we were confronted with many novel legal questions. These were issues which were not yet directly addressed in legal text, and also not yet been passed upon by the Supreme Court. And we give full credit for this kind of challenge, of course, to the Moro Islamic Liberation Front for putting forward very important concepts, very strategic and creative new solutions in the peace process. And if these novel concepts were never brought up by the likes of Attorney Mike Mastura, then we would never have had the occasion to confront these questions, and we would never have gone there. So these were important questions, and we are grateful that these were raised, that these formulas, solutions were raised in the course of the negotiations. And these were questions such as the concept of an asymmetric relationship, or whether an autonomous regional government, as recognized in Article 10 of the Constitution, can have a parliamentary form of government, or the notion of reserved, concurrent, or exclusive powers. or the allocation of powers between the national government and an autonomous constituent unit. Now, these questions did not end when the Comprehensive Agreement on the Bangsamoro was signed in 2014. When the BC was first constituted to draft the Bangsamoro law out of the peace agreements, we had to contend with more questions, like the conduct of a plebiscite, where the plebiscite is not merely creating a new region, but also dissolving an existing one, or the significance of the definition of a Bangsamoro identity of the exercise of political autonomy, or the nature of the autonomous region as a local government. And the comprehensive agreement on the Bangsamoro became possible when both sides accepted that for the peace process to succeed, it had to be sustainable. And to be sustainable, it had to be informed not only by the grievances of the past, but also by the realities that we have at present. It had to acknowledge the reality of having to deal with the parameters in the Constitution, inasmuch as it also had to recognize the social and political injustices and grievances of the people. The framework chapter that we have in this book offers a perspective. It is just one perspective on how to appreciate the Bangsamoro organic law, given its dual nature as an instrument for peace, justice, and conflict resolution, and as a statute or an act of Congress. It expounds on the nature of peace negotiations as a constitutional exercise, as well as the status of peace agreements under Philippine law. It lays down the legal basis and parameters for the exercise of the President's authority to conduct peace negotiations and enter into peace agreements under the Constitution. The chapter then discusses the relevant constitutional framework for the BOL, given its nature as an act of Congress. So while the negotiation and signing of the peace agreement rested on the President's constitutional authorities as Chief Executive and as Commander-in-Chief, the authority of Congress to enact the Bangsamoro law is based on its power to amend or repeal laws and its authority under Article 10 of the Constitution to create autonomous regions through an organic act. And then the chapter concludes with a note on the limitations of the right of self-determination as a framework for analysis of the BOL. I must add at this point that with the recently concluded national elections, there is a new dimension perhaps to the usefulness of this book, because recently we are once again hearing calls for federalism and charter change. And although this is hardly the first time that these proposals are raised during election season, perhaps we would be reckless to assume that these last elections are no different from the ones before. I think we are still in the midst of processing how they are in fact different. And perhaps now the calls for charter change might just actually gain traction. And if they do, it would be useful indeed for us to have a solid understanding of the Constitution before we dive into the challenging process of changing or even improving it. And for us here, this means getting a good grasp of the Constitution, both its strength, but especially its limitations, as an instrument for peace, justice, and good governance for the Bangsamoro people. The framework chapter benefits from the work of many individuals who have written about the Bangsamoro peace process since negotiations with the Moro National Liberation Front started in the 70s. I am grateful for the work of the like of Dr. Mike Mastura, IAG Executive Director Benny Bacani, who's also one of the authors of the book, Judge Saul Santos and his commentaries on the directions of the peace negotiations, a book that was recently published by Professor Marion Coronel Ferrer, where she did a discourse analysis of the armed resistance waged by the Moro National Liberation Front and the Moro Islamic Liberation Front, interventions and comments made by members of the 1986 Constitutional Commission during their deliberations, particularly Commissioner Pons Benagen and the late Commissioner and CHR Chair Chico Gascon, whom we miss today, and Professor Christine Mel in her analysis and comparative work on peace agreements from various parts of the world. I extend my apologies in advance for any shortcomings and oversight in the chapter. The book is a work in progress, almost like the experiences of transition that we are in the middle of today, of the former ARMM to the BARM. And it is an attempt to make even a minute contribution to ongoing efforts to establish meaningful self-governance in the Bangsamoro. Hopefully, one that is meaningful and impactful, not only from the viewpoint of law, not only from the viewpoint of leadership, but most importantly, from the viewpoint of the communities and its inhabitants. We submit that ultimately, this peace agreement, this Bangsamoro law, this constitution, while they're all products of difficult conversation, they will be judged in our history on the basis of whether they are able to deliver a kind of governance that is needed by the Bangsamoro, not just what they were willing to accept. And with that, I thank you for everyone for your attention. Again, thank you, Sir Benny IAG, for accommodating me by Zoom, and have a pleasant morning.
Thank you, Attorney Wama, for presenting the framework chapter of the book. Just a core message of that, and also thank you for your inspiring message also. And for your contribution to a meaningful and impactful, hopefully, Bangsamoro Autonomous Region in Muslim Mindanao. Maraming salamat po. At this point, another message we will hear from another author. He holds an executive and administrative post in the regional government of the Bangsamoro Autonomous Region in Muslim Mindanao, and was also a cabinet official in its predecessor, the Autonomous Region in Muslim Mindanao, for more than 17 years. He was in the legal panel of the Technical Working Group for the Moro Islamic Liberation Front in the negotiations of its peace agreement with government, and was involved in the drafting and legislation of the Bangsamoro Organic Law. Ladies and gentlemen, please help me welcome Attorney Ishaq Veloso Mastura.
Assalamualaikum warahmatullahi wabarakatuh. Thank you very much. First of all, I'd like to thank my father, Attorney Michael Mastura, for the inspiration to become an author. Because he told me at least once in your life you have to write a book. So I'm already 50, I've never written a book, but I have written many articles in journals. And some of them I have shared with my father as a co-author, but never a book. Unlike my father, who has been an author of many books already. And in fact, there will be, maybe this year or next year, at the latest, but probably this year, we will be reissuing his book on Rulers of Maguindanao in Modern History by the Ateneo de Manila Press. So that's something we can look forward to, and that will have wider circulation because it's been out of circulation for a long time. So, for me, the authorship of this book is highly significant because it's not just any book that we have written, but it's also a law book. You can actually use it as a textbook. Of course, the old barn, or the Bangsamoro Organic law is a very new law, so the jurisprudence is not so rich. And we were looking at the jurisprudence from the time of the ARM, and most of them are still applicable. The big difference, though, is that under the old Armed Organic Act, it was all about devolution. In this case, supposedly, under the Bangsamoro Organic Law, the devolution is the Constitution itself. Unfortunately, it created some confusion. That's why this book will contribute towards clarity in how the Bangsamoro Organic Law is supposed to be implemented. Because the Bangsamoro Organic Law did not follow the CAB and FAB formula which also my father advanced during the peace negotiation, the delineation of powers. The delineation of powers is the heart of autonomy under the cap and FAB. But if you look at the Bangsamoro organic law, it's gone. It's not there. Because Senator Drilon, at the plenary session in the Senate, said that that is unconstitutional since the Constitution already lists the powers there of the autonomous region, and all other powers that are not listed in the Constitution is in the national government. So we accept that as an implementation of the peace agreement. But there is much to be desired in terms of actual implementation of the peace agreement. So the opportunity is there. Charter change might come because we have a majority president. And there is a call again, as my colleague, Attorney Johanna said, Johanna Wahab, that federalism is in the air, charter change, or whatever form it may be, it's there. So there is that opportunity to correct in order that we can implement actual provisions of the CAB and FAB. So that's one thing. Then, ironically, President, they are calling it President-elect, but technically he's still not President-elect because it's not been proclaimed. But the irony here I'm referring to is the substitute bill of Marcos was he preserved in the substitute bill the delineation of powers. So we hear a lot of talk that Marcos was the one who prevented the BPL, the Bangsamoro Basic Law. But when you look at the substitute bill that is submitted in Congress, the heart of autonomy, which is the delineation of powers, was in the substitute bill of Marcos. So when he was criticized for claiming the BPL, actually he was right. He preserved the autonomy, but maybe some provisions of the law that he felt was unconstitutional, or his advisors felt unconstitutional, was removed. But for me, if you preserve the delineation of powers, actually which was the last advice of my father to the MILF as counsel, as their legal counsel, is hold on to the delineation of powers, which they did not. They surrendered, so this is now the BOL. And this is our authorship of that book. We reflect what is already the reality, which is the BOL. And for us, it's very important to implement the BOL as it is written now. Otherwise, we have confusion. Our problem is some in the MILF have not accepted the BOL because they think that we're still negotiating. That's why the IGR has become a forum for renegotiating what we lost under the BOL. Yung IGR is not a forum for renegotiating what you lost in the peace agreement or what you lost rather in the implementation of the peace agreement in the BOL. Why? Because the IGR is a mechanism for government. You're now part of government. You're no longer a rebel group. You're now part of the government, you're Bangsamoro government, and you're talking to a higher tier, higher level of government, which is the national government. And supposedly, the work of the IGR is continuous. It's not from time to time, it stops again like a negotiation. Because the model that I helped my father when he was still a negotiator understand and evaluate was the model of Catalonia. That's autonomous region in Spain. Under the Catalonian model, there is a permanent IGR. And that permanent IGR, you negotiate the modalities, the mechanisms, in order to implement autonomy. But only for the gray areas. For all other areas that are clear in the law, you can already start implementing it. That's the rule of law. But if your IGR is only meeting every quarter, Joe Loren was saying, we haven't even constituted what is the territory of the Bangsamoro. We have not constituted the 63 barangays. So we don't even know what is the territory of the Bangsamoro. We have not defined it. That was the very first border. I know the late Gajai Jafar, the vice chair of the MILF, in some conversations, he already taught the BTA. I heard him, some also can bear witness. He said the first thing we'll do as BTA is constitute the 63 barangays into its proper form, shape. So he was concerned about preserving the territory of the barn. But now we had an election, very funny, because the 63 barangays were not allowed to vote for mayor, governor, the local officials. They were allowed to vote for national officials. So, that's the very first thing that we have to secure, the territory of the Bangsamoro. But it didn't do that. So, we have this strange animal left hanging. So, that's the first that has to be corrected in a new BTA. We have to start, as Joe said, the zones of cooperation, these 63 parents have to be settled. Otherwise, everything remains unsettled. Then the issue of color of authority. The issue of color of authority is very bothersome in the case of the barn, in the case of the Bangsamoro Organic Law, because under the old Organic Act, it was a function of devolution. So when you have a function of devolution, it's just about bringing what is in the national government authorities into the barn. And the dates are guided by laws, meaning with charter siya. Each agency has its charter, so you can bring down the powers. And there's no confusion with regard to the public into which agency they will apply and get approvals, permits, and everything. But right now, everything is merged. So there are rumblings, there are issues already with regard to credibility, integrity, and recognition of issuances coming from the barn government. One of those is issuances, for example, of skills certification, standards. Because if it's only applicable in the barn, it's not applicable. For example, you're going abroad, you get a TESDA certification and it's not recognized by TESDA Manila. What happens? You can't go abroad. So these things, what is happening is we are creating a culture of color of authority. Color of authority, sa Tagalog, color room. So, this is our contribution. Itong aming, this book of ours, is our contribution to return to the basics, which is the rule of law. And in this case, I'm reminded that in the case of China is a communist country, but they have rule of law. It might be harsh, but they have rule of law. So here in the barn, we have this BOL, but if we only impose color of authority, meaning authority that emanates from the person, meaning we follow only rule of law in accordance with the statements or the implementation or the orders from the authorities. That is not rule of law. That's only, that's only like pre-modern culture. Actually, going back to pre-modern culture, wherein the Datu, the chieftain, the head of a clan is the one saying what the law is. So we have to go back to the foundations of the law. And this is the BOL. That's why I'm very proud of one provision that I studied there, the Article 5, Section 2, which is the powers of government, wherein I analyzed and unpacked what it means when you say that the powers of the barn are subject to national law. Because that phrase, subject to national law, is very significant in the case of the BOL. Because for the very first time, it's very clear there that the constitutional provision that all autonomous powers subject to national law is read into the BOL. In the case of the Armed Organic Act, this was not so. Why? There was some leeway. Actually, very well crafted yung Armed Organic Act. Why? Because in the case of the Armed Organic Act, aside from the statement that it exercises all powers devolved to it, and under its Organic Act, it limited the intrusion of national law because of the hierarchy of laws. Meaning, the Organic Act was primary, secondary only national laws. But when you lost the delineation of powers in the case of the BOL, we lost that hierarchy of laws. And what is the glaring example of this? The extension law, the postponement of the barn law, the postponement of the barn elections law. Why? Because it did not have to undergo plebiscite. In the case of the Armed Organic Act, before, it had to undergo plebiscite. So, in this case, anytime Congress wants to change the BOL, it can. Anyway, there's also a ruling already by the Supreme Court that only the core powers, only the ones in the Constitution that are named there, the 10 powers that are named in the Constitution, needs a plebiscite. But because we unpack it without a proper delineation of powers, there is confusion. So, our attempt in this book is to go back to the fundamentals. What is the rule of law? And we hope that we can contribute to the conversation here. It's not the perfect or best in interpretation, but it will evolve in time. But if you look at the authors here, I think they have enough experience. They have enough depth of experience and expertise to say what the law is under this interpretation or under this annotation of the Bangsamoro Organic Law. In my case, we have two authors at least of a Master of Laws. I have a Master of Laws from the University of Dundee, Scotland, Attorney Johanna from Georgetown University. Joe Lorena is an experience from a government official from the days when he was with Labor to the ARM. He was Attorney General of the ARM under Marukusin. Then he also went to OPAC. He was the Undersecretary. So he had so many experience with regard to the BARM and the Bangsamoro. The same with Attorney Mitmuk. Attorney Mitmuk was Deputy Executive Secretary. He was also the Deputy Secretary. He was also the RLA Speaker. So we bring a wealth of credibility and experience with regard to how a law is implemented and how a law should work under an autonomous setup. And of course, Benny is the only Institute of Autonomy and Governance, the only institution standing now with regard to policy. All the others, apparently, they have either become NGO or CSO or collapsed under the foreign government. But at least we still have a policy institute locally based here in Cotabato City, the Institute of Autonomy and Governance. And we're not to thank the IAG and the Australian government for allowing us to publish this book. So we hope that this is just the start of the conversation. We hope that this book can contribute to the policy analysis, policy assessment of the incoming national government, incoming president, and whoever these officials will be. So my challenge to many, the IAG, is to continue this kind of discussions, conversations, so that the people can be updated and know what's coming, or at least anticipate what could be changes or what could be the implications of a new administration. And I will not discuss that anymore because Attorney Joe Lorena already discussed that very thoroughly with regard to the dangers, the challenges, the risks. And I think PTA member MP Attorney Rasul Mitmuk will discuss that more. So with that, I thank you and I end my speech.
Thank you, Attorney Shah. Maraming salamat po for impressing on the implementation of the rule of law and of course, talking about the critical provisions of the law. So at this point, we would also like to hear a message from another author. He graduated from the Juris Doctor program of the Ateneo Rockwell Law School. His first engagement with the Bangsamoro was as a human rights lawyer in the Mindanao Human Rights Action Center. He was a consultant for Senator Chotistico Ingona III for the Autonomous Region in Muslim Mindanao and has served the then ARM in various capacities. Ladies and gentlemen, please help me welcome the Deputy Minority Floor Leader, Member of the Parliament, Attorney Rasul Mitmuk.
Maraming salamat po. Assalamualaikum warahmatullahi wabarakatuh. Magandang umaga sa lahat. Good morning, everyone. First, I would like to syempre, send my salam to everyone as a form of my greetings and courtesies. Second, I would like to thank IAG and Australian Embassy for being able to be part of this book and a team of researchers. What we wanted in the beginning was just a small website wherein we put notes, wherein critical information or rules or resolutions that has come up with in the parliament, so that everybody will be updated with Bangsamoro and its development as a law and how it's being implemented in the bar. But with IAG and the group of dynamic authors, we are very lucky enough because I and some of our researchers here, Gandhi and Attorney Lee, we were able to learn from good authors ideas about the POL. It is good to know that not all of the ideas are the same, meaning some of the opinions of Attorney Shak, Attorney Johanna Wahab, Benny Bakani, and Attorney Joe Lorena are oftentimes conflicting. And you can find that on the book. They have provided portions wherein this is one of the opinions, this is one of the positions of each of the ideas of each author. So the book is actually intended to provide more space for everybody. For example, right now we have 2,000 new lawyers, and some of them might not have been following the peace process. Some of them would have been hearing the peace process or the development of autonomy from peers. For example, I studied law in Metro Manila, and if you put or compute all the time that we focused on the ARLM or the autonomy law, I think it's just a day or two, or at the maximum a 1 week session on what is autonomy. So this is an opportunity to learn. So this is an opportunity through the book. We open up the conversation. We start the conversation for everybody. This is for the farm. Before in the ARM, we only have the IBP of Lanao, which is under the autonomous region. But right now we have Cotabato City, IBP Maguindanao, and IBP Cotabato. So there's many people who can discuss about the book. It's not just the lawyers. Everybody can start reading and contribute something for the Bangsamoro. And this is our hope for this Bangsamoro handbook. So everybody can start discussing it, and everybody can take a position in the bar as it is intended to. Maraming salamat.
Maraming salamat. Thank you, Attorney Ras, for that message. So at this point, before we close, I'll give you the closing remarks. We will distribute the books before the people. No need for you to get your copies here. The secretary will be distributing the books. We'll be giving 2 copies to the schools who are here for your library. Okay? So, signed copies na po ito. Sorry, press signed copies. So at this point, we shall now be closing our event for this morning. Please help me welcome Ms. Mary Jacqueline Fernandez to give us the closing remarks. I invite the Deputy Executive Director.
Thank you, Sheila. Good morning and Assalamualaikum. The launching of the book Organic Law for the Bangsamoro Autonomous Region, Framework and Annotations is another milestone to celebrate as IAG remains steadfast and committed to contributing to the peace process in Mindanao and in helping shape public policies in the region and in the country. We would like to express our sincere gratitude to the Australian government for their support in the publishing of this book. The Australian government has been IAG's longtime partner, particularly in implementing interventions and projects that help promote good governance in the Bangsamoro. We also thank the legal researchers who assisted us in the writing of the book, Attorney Jehan Haro, Ms. Sarah Lawan, Mr. Abdul Hamid Alawi Jr., who is here with us, David please, Ms. Yasmin Makaumbang, Mr. Ali Alrasid Umpa, Ms. Janisa Makapantar, who is also with us. Thank you. Ms. Roxanne Ledesma and Mr. Mardonio Chester Agbayana. Thank you also to IAG's communication team headed by Mr. Rami Toledo and to Jess Foresma for the layout and design of the book. And to our very own AMPOL team headed by Professor Tila Gabriel and to all those who helped and gave their support. To the esteemed authors of the book, PTA members of Parliament, Attorney Jose Lorena Jr. and Attorney Rasul Mitmog Jr. Chair of the BARM Regional Board of Investments, Attorney Ishaq Mastura, our very own Executive Director, Attorney Benedicto Bacani, and Attorney Juhaira Wahab, the Third Secretary and Consul of the Philippine Embassy in Malaysia. Thank you very much for your hard work and commitment over the last 2 years, resulting to this very important publication. And to all of you who joined us in today's launching, maraming salamat po. We hope at IAG that this book and all that it seeks to achieve will be useful to all of you in your pursuit of knowledge for lasting peace in Mindanao. Again, on behalf of IAG, shukran, maraming salamat, and have a good day.